Need to have the debate in English because Kirsten from the Coalition for the International Criminal Court and Matthew from the who is professor at the University of Luxembourg will basically speak in English. Just to briefly introduce myself, my name is Philippe Thibault and I am a member of Amnesty International. And to start, maybe I will ask Matthew to briefly describe what is exactly the ICC in a few words. I know it's difficult, but it's a very difficult exercise. But as you're a professor, you are very well trained to teach.
Yeah, but maybe not in a few words.
In a few minutes.
Yeah, okay. Well, the International Criminal Court was, I'm going to keep this fairly basic, so don't blame me if you've heard it all before. It's an International Criminal Court. It was created by treaty, the Rome Statute of the International Criminal Court, which was adopted in Rome on 17th July 1998. As we saw from the film, the court sits in a rather delightful building in The Hague, which I think used to be the offices of an insurance company. But they are promised a new purpose-built court. It consists of 4 organs: the presidency, the judicial divisions, the office of prosecutor, and the registry. So you have the really important things for our purposes. If you have the office of the prosecutor, which investigates situations, prosecutes individuals before the court, and then you have the various chambers of the court, which judge the accused and which supervise the activities of the prosecutor as they investigate particular cases. And there are 2 levels, so it goes to trial first, and then there's the possibility to appeal at any judgment to the appeals chamber. The important thing, I think, perhaps the most important thing to remember about the court is that because it was established by a treaty, by an international agreement between states, to a very large extent, well, the statute itself, the Rome Statute, only binds those states which have consented to be bound by it, which have become parties to the statute. And that distinguishes it from the ad hoc tribunals that were earlier created by the UN Security Council, the International Criminal Tribunal for the former Yugoslavia, the International Criminal Tribunal for Rwanda. The difference being that the Security Council of the United Nations, the executive body of the UN, if you like, is able, when acting, in particular against threats to international peace and security, to impose obligations on the UN member states. So when those tribunals, when those ad hoc tribunals were established, the member states, the UN member states, were obliged by the Security Council to cooperate with those tribunals. In distinction from the ICC, though, those tribunals, as their name suggests, those ad hoc tribunals, only deal with specific situations, and they have really quite temporally and geographically limited mandates. The International Criminal Court potentially could really deal with anything, providing states were willing to let it do. But there is this consensual nature. Its jurisdiction is really based on state consent. The Rome Statute came into force. It needed 60 states to become parties, I think. It came into force on the 1st of July 2002. Presently, or at least as of the beginning of this month, I checked the website this morning, there are 122 state parties to the Rome Statute, which sounds pretty good, actually. You know, it's nearly 2/3 of states in the world today, but including Luxembourg, of course. Luxembourg ratified the statute on the 8th of September 2000, some time ago. However, if you look, you find that the ICC is more popular in some parts of the world than in others. So it's popular in Europe, in particular. And what is not popular, where you find, so the UK and France as permanent members of the Security Council are parties to the statute, but the other 3 permanent members of the Security Council, the US, China, Russia, are not parties to the statute. And there are not an enormous number of Asian states in particular, and basically none nearly none, in the Middle East, North African region. Off the top of my head, I think Jordan. Is that about it? Yeah, I think Jordan. So, its coverage is by no means really global. What's the court do? Well, it's there to judge the most serious crimes of concern to the international community, which means it deals with really 4 categories of crime: genocide, within its jurisdiction, genocide, crimes against humanity, war crimes, and interestingly enough, at least potentially, the crime of aggression, that is, waging aggressive war, invading other countries. However, the court can't yet exercise jurisdiction over that crime. There have been amendments to the Rome Statute were adopted in Kampala by the Assembly of States Parties in 2010, which defined the crime of aggression, said actually what it was, and provided for the court's jurisdiction over it, the conditions of jurisdiction, but they haven't yet received sufficient ratifications to come into force. I think there's about six, with a couple coming up out of the 30 necessary ratifications. Luxembourg's one of them as well. Obviously, the government of Luxembourg doesn't feel that it's likely to be. The leaders don't feel they're likely to be prosecuted for aggression, but other countries maybe. I don't know. The UK might feel differently. I perhaps shouldn't comment. It's sometimes said, so genocide, crimes against humanity, war crimes, and aggression, at least sometime in the future, we hope. Now they're crimes under international law, and it's often said they're crimes of universal jurisdiction, which means that any state that gets their hands on someone alleged to have committed upon those crimes can prosecute. So the classic example would be the trial of Eichmann in Jerusalem back in 1960. No connection whatsoever with Israel. He wasn't an Israeli national. The crimes weren't committed in Israeli territory. In fact, they were committed before the state of Israel even existed. And for that reason, obviously, weren't committed against Israeli nationals either. Nonetheless, generally thought that Israel was entitled to exercise jurisdiction over Eichmann. But that's not how the International Criminal Court works. It can only exercise jurisdiction, to simplify somewhat, in 2 situations, which 2 plus 1 is 3. One is when the alleged perpetrator is a national of a state party to the statute, and the other is if the crime allegedly took place on the territory of a state party. So it's based on, if you like, it piggybacks off the state party's jurisdiction. It's generally agreed that all states have the right to try their own nationals for offences under their own national criminal codes and to try individuals for offences in their own territory. And the ICC, if you like, gets delegated that power, but it doesn't have universal jurisdiction, except in one circumstance, in one situation, which is an interesting one, because the ICC is entitled to exercise jurisdiction when the UN Security Council refers a situation to the court. And in that case, the UN Security Council can really refer any situation. It doesn't have to be a situation that's occurred within the territory of a state party to the Rome Statute. And we've seen that on 2 occasions so far, the first being Sudan, Darfur, and the second being more recently with regards to Libya. So that has happened, despite the fact that the US originally was really, really against the ICC. It's sort of come around to it, at least, when doesn't want to become a party, but it quite likes the fact that the Security Council can use the ICC. Obviously, the Security Council is only meant to do that when it's acting in pursuit of its role to maintain, to restore international peace and security. So immediately we come into the idea of what is the relationship between the ICC and at least international peace and security. The court's jurisdiction is also temporarily limited, so it can't go back and look at events that took place before it was established, before it came into, or sorry, before the statute came into force. In addition, and this is, I think, one of the more interesting things about the court, even if the court does have jurisdiction, a particular case may nonetheless not be admissible, and in particular by virtue of what's known as the principle of complementarity. And what's complementarity? This is the operation of the ICC is sometimes said to be entirely premised on this idea, and the idea is that it's complementary to national jurisdiction. So the idea is, first of all, hopefully people who commit these very bad crimes or are alleged to have done so will be prosecuted at the national level. Investigated, so you should get investigations and prosecutions at the national level. And so consequently it's the case that if a case has been or is being investigated or prosecuted by a state with jurisdiction, it's inadmissible before the court. It's admissible only if the investigating or prosecuting state is or state should be doing that, is unwilling or unable genuinely to carry out that investigation or prosecution. And that's an issue at the moment for example, with Libya. The Libyans say they want to try the two persons who've been there's now two, because Gaddafi died, he's killed. But there is a question, the Libyans say, we've got them, we want to prosecute them, and there's a question of what the court should do. What else? Well, I think this is good, because what it means is if you're a state, if you become a party to the Rome Statute and you want to avoid the court investigating, prosecuting situations, regarding your nationals or that have taken place in your territory, there's a really easy way to do so, and that's do it yourself. And what that's really encouraged quite a lot of states to do, and this is something that's also been pushed quite hard, is to incorporate the crimes that the court has jurisdiction over, genocide, war crimes, crimes against humanity, into their own national criminal codes. Now, they were crimes under international law before, but most states, even states that take a monist view, that is, that they think international law is by and large part of their national law, generally require that for an international crime to be something that can be prosecuted in the national courts, it has specifically to be incorporated into their criminal code, and that's happened a lot more. So far more states now have proper legislation concerning these international crimes. Maybe they don't want to use the legislation, but it is there, and it can be used, hopefully. I see I'm losing my audience already, so I probably should wrap up. So the court obviously has jurisdiction over individuals, but how is the court seized with any particular situation? I'll just say something about that and then I'll stop. Essentially, I can't complain to the court, I can't get the court to investigate anything. Individuals aren't involved. So it's basically either state parties can bring situations before the court, as can the Security Council, I've already mentioned that, and then the prosecutor himself, or now herself, can also act on his or her motion and start investigating a particular situation. In most cases, oddly enough, the cases brought before the court have been, or situations brought before the court, have been the result of what have been called self-referrals. So states have actually said, look, we've got a situation within our territory and we want you, the International Criminal Court, to investigate it, which might seem a bit odd. But as we can see in Uganda, what the government there did, and it was the government of Uganda that referred the situation in northern Uganda to the court. What the government there was doing was saying, well, we want you to investigate the LRA, not the situation, but we've got these bad people in our country, we can't deal with them. We want you, the court, to come in. Now, whether that's always desirable is, I think, an interesting issue. At the moment, there are 18 cases in 8 situations that have so far been brought before the court. The situations are those in Uganda, Democratic Republic of Congo, Sudan, Darfur, Central African Republic, Kenya, Libya, Cote d'Ivoire, and Mali. And of those, Uganda, Democratic Republic of Congo, Central African Republic, Cote d'Ivoire, which is a slightly odd one, and Mali was self-referral, so the government of those states referred the situation to the court. Sudan and Libya were referred by the Security Council, I already mentioned that, and Kenya, which is the only one that has been, the investigation was initiated by the prosecutor. Kenya's not going very well at the moment. They've just had elections in Kenya, and they elected as president and vice president 2 individuals who've been indicted by the court. So, well, we'll see. And I should probably shut up there, and you can hear all the gory details from my...
So, Kirsten, maybe you are from the global regional coordinator for Europe for the Coalition for the International Criminal Court. Maybe you can explain briefly what is exactly this coalition and the work that is doing on a daily basis in connection with the International Criminal Court.
Sure, thanks. I don't know how bloody or gory these details about our organization will be. I hope not very. So I'm Kirsten. I am the regional coordinator for Europe for the Coalition for the International Criminal Court. Our organization was started in 1995 when a group of NGOs working on various human rights issues got together on the heels of the creation of the ad hoc tribunals for Rwanda and the former Yugoslavia, with the desire to create a system of international justice that would be permanent. As you may know, the ad hoc tribunals were created in relation to very specific situations, former Yugoslavia and Rwanda, and in relation to very specific time periods. They did not have any jurisdiction over other situations that may have come into consideration subsequent to their creation. So this group of NGOs decided to create a coalition to work together in support of the creation of the International Criminal Court. And so our organization was created in 1995, and at the Rome Conference in 1998, under the umbrella of the coalition, there were some 300 representatives of civil society participating actively in the discussions in Rome, which was pretty incredible that civil society had such a role to play in what was basically the negotiations of an international treaty. Furthermore, in Rome, civil society played an important role in ensuring some of the most important aspects of the Rome Statute, for example, in relation to victims' participation in the proceedings before the court, as well as many aspects related to the guarantee of fair trial rights, even for the accused, among other elements of the statute. Going further, the coalition and its membership continued to grow, and we focused in the years following Rome to push for those necessary 60 ratifications for the entry into force of the Rome Statute, which, as my colleague mentioned, took place in 2002, leading to the establishment of the court. Now, the establishment of an international criminal court, as you can imagine, is not a thing that happens overnight. So it took a number of years just to set up the actual institution, recruit staff, make sure that they were well versed in what they were going to be doing, understanding their mandate, coming together with the different legal systems that actually the Rome Statute tried to bring together. And so in those early years following the establishment of the court, the coalition's membership worked a lot to help with its effective establishment, but also its effective functioning. Since then, I think I can say in broad terms what the coalition does today. Well, first of all, we have a membership of over 2,500 NGOs around the world, coming from 150 countries. Okay, so more than the states' parties, so hopefully that'll lead to some future ratification. We work on what's called the universality of the Rome Statute, so again, encouraging ratification of the Rome Statute, but also its implementation. As was already mentioned, we see it as an obligation of states to implement the provisions of the Rome Statute, so to ensure that their national legislation includes the crimes included in the Rome Statute, as well as provisions for cooperating with the court. It's not, for some states, just a simple measure of picking up the phone and saying, yes, we will work with you as the court, but they actually need provisions within their legal systems to allow for that cooperation to be effective. We also work to ensure that the Rome Statute, as an international treaty, maintains its integrity. There was a review conference in Kampala, Uganda in 2010, where the amendments leading towards the crime of aggression definition, as well as another amendment related to the extension of crimes to conflicts of a non-international character. These two amendments were passed in Kampala, and part of our work is to ensure that the Rome Statute as a treaty as a whole, including now these new amendments, retains its initial integrity in respect of ensuring that there is an end to impunity for these international crimes. We also work to encourage support for the International Criminal Court and the international justice system more broadly. It was mentioned already, this principle of complementarity. The ICC cannot be seen as a single entity operating on its own out there. It is actually the building block of a full globalized international justice system that the Rome Statute created, whereby the primary duty, the primary obligation to investigate and prosecute these international crimes lies with states. The ICC is meant to come in as a last resort. States cannot, they don't have the capability or the political will to investigate or prosecute these crimes. That's when the court comes into action. So we work with states, whether they're party to the Rome Statute or not, to make sure that they have the implementing legislation that I mentioned, but that also that they have the training, the technical capacity and expertise needed to undertake these investigations and prosecutions at the national level, which we see as an ultimate goal, not only for creating ownership of the justice process, but because it brings the whole thing closer to home and ensures that the communities are well informed about the process as a whole. I think that is a broad overview of our organization's work, just to give you a bit more of an idea of who makes up the Coalition for the International Criminal Court. Again, 2,500 members around the world. Sounds like a lot. How on earth do we coordinate that? It takes a lot of work, obviously, but our role is to facilitate the work of our members, to serve as an information exchange. We assist members, whether they're local, national, regional, or international members, to carry out campaigns in support of the International Criminal Court. We provide trainings even to states in terms of working on implementing legislation, or, for example, how to overcome constitutional obstacles to ratification, which is something that many states yet to join the Rome Statute are faced with today. And we also work a lot with the court itself. We're not we're independent of the court, and we don't support every single thing that the court does, despite what might be indicated by our name. But we and our membership can serve as a critical eye on the court, on its functioning, on the role of states that are party to the court, and many of the debates, such as tonight's debate, that turn around its functioning.
Thank you. So maybe we can go into the debate right now. After having looked at what's documentary, the question that we would like to ask is, you know that there are two opposite and clear-cut positions that are shown in this documentary, which are, on the one hand, you have people saying that the ICC has basically jeopardized or almost jeopardized the peace process that was ongoing, and there was negotiation, and then in the end Joseph Kony could not sign or could not agree to a peace process to move forward because there was the ICC investigation that were ongoing against him and members of the LRA. And on the other hand, you have people from the ICC itself who said, and the prosecutor, chief prosecutor Ocampo, was leading the debate, who was saying that no, what anyway, what Joseph Kony is doing is that he's playing fool with everybody, and he does not want peace. He wants a war, and what we are doing is right. So, what is maybe your view to both of you on that point?
Well, it's difficult to know. I can't see in the head of Joseph Kony. I'm not sure I'd want to. I found the film interesting but slightly annoying, actually, for, I think, 3 reasons off the top of my head. The first is, I think the dichotomy is a bit facile, frankly. I'm no enormous expert on what people think in northern Uganda, but it does seem to me that different groups of people in the area have different views as to what they want to happen. And it's, I think, quite interesting, for example, that the groups that are and that have been pushing sort of reconciliation, traditional justice mechanisms, tend to be groups with an interest in doing so. So they tend to be religious leaders, and they tend to be traditional chiefs. That's the first thing. The second thing is, you talked about the widespread displacement by the Lord's Resistance Army. Now that is true, but a lot of that displacement into camps has also been undertaken by the Ugandan People's Defence Force in order to, they say guerrillas are like fish in water, to take the water away from the fish. And those camps, I think they're better now, but they have been places of incredible structural violence with extremely high mortality rates. I'm not sure that's something that can be entirely blamed on the LRA. I think the Ugandan government has to take some blame for that. And thirdly, the film rather downplayed the international context. Now, the Ugandan government, during quite a lot of the period while this was going on, was in fact engaging in a war of aggression in the Democratic Republic of Congo and supporting quite a number of very unsavoury militias, which were also doing such things as recruiting child soldiers, engaging in systematic rape and massacres and so on. So, you know, I'd simply say I don't think the documentary tells the whole story, which is complex. And in a way, also, the problem is that Joseph Kony is, as they said at the beginning, he is the motor of the organisation. It's a particularly appalling organisation. The piece with justice, its dichotomy, you know, it's perhaps at its starkest here, but what guidance does it give us for other situations? So I realise I've raised more questions than I've answered, but that's how I see my role as an academic.
Well, I agree with actually what you said, so sorry for not making this much of a debate. But I think what's interesting in the film, I agree that there's the dichotomy is perhaps falsely portrayed in the film. For example, we have a national coalition for the ICC in Uganda. We have 200 civil society members in Uganda who are all in support of the International Criminal Court. I didn't see those voices reflected in the movie, but I can attest to you that there are voices that are in favor of the International Criminal Court's activities as relates to Uganda. I think also it was said at one point in the film, we don't want the ICC, we just want forgiveness, and the ICC is a Western neo-colonial construct. The traditional mechanism that is outlined in the film, the Mato Oput, is very interesting because when it's presented in the film at the same time, they point to the fact that it's necessary to go through this ritual because without reconciliation, people will seek revenge. the cycle of violence will continue. So in the traditional justice mechanism that they depict, there is an acknowledgement that accountability is necessary to peace. If it takes the form of an international tribunal, such as the ICC, a national court, as per the principle of complementarity, or a traditional justice mechanism, at the end, the same result is there. Accountability, justice, redress to victims is what is sought at the end of the day. And I don't think that you can pit them against each other. Nobody in the, I think, there on the ground or here in this audience, I think, thinks it's peace versus justice. Oh, we can only have peace or we only have justice. They go hand in hand. They complement each other. You will never have a sustainable peace unless you have justice, unless you have a record, a public acknowledgement of the crimes that were committed, public acknowledgement of the sufferings of the victims, and a historical record to which people can refer in future generations to be sure that they know, okay, this is the person who is responsible for these crimes. And I think that's something that's also interesting with the ICC is this, it is towards individuals. It's taking individuals before the court. It's not like the International Court of Justice dealing with states. It's taking individuals. And by individualizing the responsibility for these crimes, it removes the collectivization of guilt, which again leads to cycles of violence, because if you name one group as being responsible for crimes, then that's going to be referred to in future generations, and you're not going to be able to get beyond this conflict. And I think also the point about seeking accountability, why it's so important here, is it sends a message. And I think that was one thing that was said in the film about how world leaders are thinking, they're having second thoughts about how they are conducting military activities. There's a lot of anecdotal evidence about, for example, even in Afghanistan, Taliban leaders who refer to the Rome Statute when talking to their forces to say, don't do these crimes, I don't want to go to The Hague. And if only for that reason, I think this debate in a way serves no purpose, because at the end of the day, what we are going to do by seeking justice is you're getting that long-lasting peace.
Maybe you can raise questions later on, but
not a question, but maybe a comment. I think from a lawyer's perspective, who lives in a jurisdiction where you have courts and tribunals that work, the most shocking message in the movie is that while you refer to accountability and having an institution which could hold you accountable, in respect of that example, for Uganda, you see that it isn't working. And that's a strong message, I think.
You mean that the institution, the ICC, is not working in the context of Uganda?
But you don't have a final result in the end.
Well, I think that this is one of the fundamental criticisms of the International Criminal Court and the Rome Statute system. We mustn't forget that the ICC was created by states, and it needs states to function. It doesn't have its own police forces. It can't fly into Uganda and arrest Kony itself. I've seen their staff. They're not adept for doing it. They need states to go in. States have the military forces to do it. States' fundamental obligation to cooperate with the court includes the execution of arrest warrants. So they're the ones that have to do it. Now, Uganda is a state party. Uganda should execute that arrest warrant. Granted, there are difficulties, but the blame should not fall on the ICC as an institution for not being able to do something that A, it does not have the mandate to do, and B, it's the responsibility of states to do.
I think there are a lot of things we can blame the ICC about, but that's not one of them. I'm sort of slightly sceptical, I have to say, about the sort of influence of the ICC. If I wanted to be cruel, I'd say that the plural of anecdotes is not data. I think, you do get people saying this, but if I were a Taliban leader, on the Afghanistan-Pakistan border, I'd be more worried about being taken out by a drone strike than taken to The Hague, even if I did have to share a cell with Laurent Gbagbo. I think that sometimes you have conflicts, and the last thing on leaders' minds is being sent to The Hague. They're worried about winning an internecine struggle, and I think, and there's rather depressingly, the message in Africa at the moment seems to be that if you want to avoid going to The Hague, the best thing is to be head of state of your country, as we now have 2 presidents who are in Sudan and Kenya who are indicted by the International Criminal Court. And I have to say the African states don't seem particularly keen on putting their confreres in front of the court. If you lose power, like Laurent Gbagbo, you go to the court. If you retain power, you're in quite a good situation not to go for it. Now, that's not, I should say that is not a reason for not having the International Criminal Court. I happen to be a big fan of the court. But I think that, to be slightly provocative, I think that sort of human rights activists in particular like to stress the deterrent effect of the International Criminal Court, because by and large, being nice people, we don't like ideas of retribution and incapacitation. But those are also aims of criminal justice. And I think the court's as much about them, if not more so, than it is about deterrence.
Thank you. So maybe one related question regarding the way the International Criminal Court works or has worked in Uganda. Uganda has referred the case of Judge Coney and his brothers in arms in 2003 to the International Criminal Court, and then in the documentary there was a point that was made that Joseph Kony will not sign any peace agreement if he has no insurance or something like that he will not be prosecuted and tried before the International Criminal Court. But once the process has been launched and that the state or the Security Council has referred the case to the International Criminal Court, is there any discussion as to stop investigating or stop a trial?
Yeah, the Security Council can stop things happening for 12-month periods. So, if you can convince the Security Council that you should stay proceedings, you can do it. The other thing is, of course, maybe you can have national prosecutions if the court thinks that they're not launched to shield someone. The more interesting one is Amnesty's traditional justice mechanism. Are they something that the court should take into account? Different commentators say different things on that in terms of admissibility. And that's, I think, the really interesting one. If you look, there are a number of societies which have taken the view, when they are transitioning from one regime to another, or when they are seeking to end a conflict within that society, that there should be some form of amnesty. You saw the really famous one is the South African Truth and Reconciliation Commission, which essentially said, if you come before the Commission, if you've been involved in political violence, if you come before the Commission, if you give full disclosure of what you did, you will be amnestied. So the idea is you get a historical record, you get people acknowledging what they do, but they avoid punishment. You see it elsewhere, and just take an example from my own country, of course. There was the Good Friday Agreement in Northern Ireland, which did result in quite a number of individuals convicted, paramilitaries they're called, terrorists, members of the groups involved in the peace process, essentially being amnestied and let out of prison. So, there are various compromises made within various societies, and the question is, what discretion should we give to those societies, and when do we say those choices are not valid? A very interesting example is what happened in Uruguay. Uruguay transitioned from dictatorship to democracy. Then there was a question whether there should be an amnesty or not, whether the amnesty, I can't remember, I think it's whether it should be listed. And it went to a referendum. Now there was very sustained pressure put on the electorate that if they didn't vote the right way, then maybe the military would take power again. And it was decided the amnesty should be maintained. This is some years ago. The situation's different now, I'll come to that. But the electorate decided that they'd rather the imperfect situation continue than take the risk. Should we say that's not a risk they're entitled, that's not a decision they're entitled to take? Particularly, and this is what I think is really interesting, particularly because you can always reopen these issues a few years down the line. And that's what we're seeing in quite a number of states where there's been some form of amnesty, or at least a decision, informal decision that there shan't be prosecutions. After a few years, things settle down, people start saying, maybe we should reopen the decision. So the question is, what discretion do we, the international community, give particular societies? When do we allow them to make, what are the ambit of the decisions we allow them to make?
I think on the issue of amnesties, there's a sort of growing agreement. I wouldn't say that it's universal, but a growing understanding, agreement that amnesties are okay, but not for mass international crimes of this great nature. And we're seeing them being applied, I think, still less and less than in the past. Partly because amnesties set a very dangerous precedent. They imply that you can get away with these crimes. So where's the incentive to not take up arms again after you've concluded peace negotiations and gotten all of the bargaining chips and food and money and whatever else you got out of it? A few years down the road, if your other conditions aren't met, for example, a position in the seat of government, what's to stop you from going back out and committing the terrible crimes again? You faced impunity before. I think that's one of the main concerns of, let's say, the international justice community, is setting this precedent. It's not just in the national context, also it's setting it internationally once again. Deterrent effect, I don't want to over-exaggerate it either. I think the jury's still out. I think it's way too soon to have concrete data on the deterrent effect of the court. But I think that there are aspects of marginalization of those suspects that are wanted by the court that contributes to creating a situation where people understand that these crimes will not go unpunished, that there is accountability and that justice is served.
The one fundamental question would be, you can imagine that in this documentary position taken against the ICC is the ICC could be an instrument that jeopardizes a peace process, that could jeopardize a peace process. I can take an example. If, for example, Bashar al-Assad in one day would want to make peace, maybe he would want immunity as Joseph Kony may have wanted immunity as well, or amnesty, or whatever that could secure him not to be prosecuted by whoever, and it could use this as a bargaining tool in negotiation. But for Bashar al-Assad or whoever else, any dictator in the world that would be in the same situation, then he would always have on the back of his mind a situation where then I could always have a referral of the Security Council to the ICC of my case, I could always have a state that will want me to be prosecuted. So what is my incentive to make peace? That's the question that was raised for Joseph Kony, and maybe if you...
Yeah, indeed. I think these things are very context specific. I've got a cartoon on my wall in my office. It has this chap giving the speech at the graduation. All these students have done their law degrees, and he's talking to them, and he says, you know, when you came to us at the beginning of your bachelor's degree 3 years ago, if you were asked the legal question, you would have to shrug your shoulders and say, I have no idea. But now, after 3 years top quality legal education, you can stand there, and with all the authority you can muster, you can say, it depends. And I sometimes think, it depends. Yeah, amnesties can set a really bad example, and I think amnesties on their own actually, you know, are not brilliant, but you often see them as part of you can see them as part of a peace process, which involves things such as disarmament, elements of truth-telling, etc. And as I say, it always leaves things open. They don't really bind on the long term, so it does leave things open. Yeah, it does. There is, you know, I tend to think that sometimes you might want to let someone out for a bit. You know, you can always change your mind later. But we don't know. We don't know. Did Colonel Gaddafi go down fighting because he was worried about going before the Hague Court? You know, did that stop his surrender or his leaving the country earlier? Or did he go down fighting because that's the sort of guy he is? We don't know. And that is the really difficult thing about this. These questions, I think they're very, very context specific. And at the end of the day, we can't see in people's minds. Bashir al-Assad, I have no idea.
It depends.
So now let's talk about justice. One general idea I think that at least your question have supported is that there is no peace, no reconciliation without justice, and this is also, by the way, the position of Amnesty International. And maybe could you tell us about the role of what the ICC could play in this respect, and that the ICC has already played, maybe by concrete example of ICC's work and judgments in bringing justice. For example, there has been one judgment that has been rendered against Thomas Lubanga, and what are the consequences, the impact of this judgment from an international standpoint, or for people living in Congo? If you can maybe...
I think the ICC works best when it's working with, when it's got state cooperation, and when it's working with other organisations. And of course, what you see in the DRC is it's got the largest UN peacekeeping mission, I think possibly ever, actually, with a big political component and a very big military component, which has had, which has been given quite considerable enforcement powers. So the DRC is, you know, in a way very different from Uganda. I mean, I'm not sure that the Lubanga trial is really, you know, a great example of anything, actually. For a start, he was prosecuted on incredibly narrow charges, essentially just child recruitment. And I think that had a lot to do with the fact that the O2P wanted to get hold of him, and he was already being he'd been indicted for a number of other crimes before the Congolese courts, and they were able to say, well, complementarity doesn't apply. here. These are crimes that he's not being prosecuted for at the national level. But it's some time since I read the enormous numbers of pre-trial documents. Also, the trial took years. It was nearly thrown out twice because of essentially prosecutorial misconduct. And I think he got 12 years, is that right? I can't remember. But given it's taken him, what, 5 years or something? 6? There, he'll be out in 6. You know, so I think it's a bit ridiculous if it takes half your sentence to actually convict you. So that's all I'm going to say about Lubanga, I think.
I agree. It's certain that the trial was fraught with many difficulties. It's had its fair share of criticism. Again, it's the first trial of the ICC. We mustn't forget that although the court started in 2002, the trial against Lubanga did not start in 2002. So we can't say, even though it's beyond 10-year anniversary of the court, that, oh my goodness, only one trial in 10 years. It didn't take 10 years to complete. But it's, and yes, there's a lot of criticism about the charges. For example, there are many victims groups that deplore the reduced focus of the OTP's case for ignoring crimes of sexual violence and rape, which were widespread, and at least if you go by reports from civil society organizations, there's ample evidence of his alleged culpability for those crimes. But at the same time, it was I think, a very important trial. Remains to be seen the impact on the ground, and how victims and the affected communities will move on from it, and how positively they will be impacted. But it was a very important trial because it was also the first trial with victims' participation. Victims actively participated in the trial. They were effectively a third party to the proceedings, which is a very interesting feature of the International Criminal Court, and I think provides victims groups with a voice that might otherwise not be heard. So that's something that we at least supported. There were 120 victims that, well, over 120 victims that participated through, I think, 7 legal counsel, legal representation, and it would also led to the first reparations decision by the ICC. Again, that
I think we've been cut off, aren't we?
Okay.
Yeah, I'm not too keen on victim participation, but then I'm a common lawyer, so there you are.
Okay, thank you both very much.
Can I make one comment? Can I just say one thing before we go? We're getting chucked out, so I'm going to rudely grab the microphone. If you're interested in children and armed conflict, this Friday, the UN Secretary General's Special Representative for Children and Armed Conflict is speaking at the university. She's speaking at 11:45 to 1:15 on Friday. We're very lucky to have her here. She's a very interesting person, and I think she'll say a lot about the way that the UN is trying to help children affected by armed conflicts, and particularly through engaging with groups that are violating their international obligations concerning children's rights and welfare. I'll be chairing it, and I'll be speaking in French, which is always good for a laugh. And if you are interested, there are flyers on the table outside. Please feel free to take one. Please feel free to come along. There are even sandwiches afterwards. If you are intending to stay for lunch, please register so we get enough of them. Thank you.
As long as we're plugging our own activities, if I may also do the same. There are some publications from the Coalition for the International Criminal Court on the table outside. At least I hope there are still some. There's also an email sign-up sheet. So if you're interested in learning more about what the coalition is doing, but also what is happening at the court, whether it's in terms of the individual cases before the court or also the investigations and preliminary examinations of the Office of the Prosecutor. You can sign up for our email. You can also visit our website. It's pretty simple. It's www.coalitionfortheicc.org. And I encourage you to check it out and learn more about the international justice system. Thank you.
Thank you both. So I invite you to come for a drink. Just there. Thank you.
Thank you. Just getting into it. Yeah, I think they've got a film in here at 9:30. Yeah.